All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
What happens when a land reform beneficiary sells or mortgages land awarded under the Comprehensive Agrarian Reform Law? And how far do the rights of an agrarian reform beneficiary extend over the land granted by the state? In July 1994, Lazaro Cruz was awarded 2 parcels of land in Kalumpit, Bulacan by the government through the Department of Agrarian Reform or DAR. In 2000, within 6 years from receipt of the award, Lazaro obtained a 1.5 million peso loan from petitioner Elizabeth Ong and mortgaged to her the first parcel of land as security. 2 years after, Lazaro executed a deed of sale over the second parcel of land in Elizabeth's favor for 1.5 million pesos. What began as a simple loan and a land sale would later turn into a legal battle over the limits of ownership and transfer rights under Republic Act No. 6657 or the Comprehensive Agrarian Reform Law. Can an agrarian reform awardee legally mortgage or sell his or her land? What should prevail? The protection of agrarian reform's social justice intent or the enforcement of private contractual rights? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 14th of November 2025, and today we talk about mortgage or sale of lot property covered by the Comprehensive Agrarian Reform Law within the context of the case of Elizabeth Ong Lim versus Lazaro N. Cruz, GR number 248650. This case was penned by Supreme Court Associate Justice Rudil V. Zalameda and decided by the Supreme Court First Division on March 15, 2023. And joining us today to discuss is Court of Appeals Associate Justice Jose Lorenzo R. De La Rosa, a member of the Remedial Law Department of the Philippine Judicial Academy. Justice De La Rosa used to be a presiding judge of a family and exclusive land registration court in the city of Manila. Hi, Justice Jolo. Welcome to the Supreme Court Podcast, and thank you for welcoming us to your chambers here at the Court of Appeals.
Good day, Attorney Mike. Thank you for having me. Hopefully, we can clarify some things today.
All right, Justice. First off, for the benefit of our listeners, what is Republic Act No. 6657 or the Comprehensive Agrarian Reform Law in a nutshell?
Basically, the Comprehensive Agrarian Reform Law seeks to award land to the farmers, to those who have been tilling agricultural land for several years, to award it to them so that they may have ownership of these lands which they have long tilled, even lands which were cultivated and tilled by their predecessors. And it goes without, nothing with regards to the landowners. They'll be receiving proper compensation for the lands taken from them. Well, it serves a dual purpose. Give land to the farmers, beneficiaries, and it seeks to unlock this really capital which is tied up in land.
And one of the features of the Comprehensive Agrarian Reform Law, Justice, is the prohibition on the sale or transfer of awarded lands within 10 years of the award. What's the logic and the wisdom behind this prohibition?
Just to clarify, so you said it's 10 years. So the prohibition is not absolute. Okay, so the prohibition prevents the awardee, the farmer beneficiary, from selling, conveying, and transferring the land awarded to them within a period of 10 years, of course, subject to exceptions. And this is really, for them to enjoy such award, for them to till the land not as a tenant, but owners of the properties or the land awarded to them.
And just to ensure that the persons who will enjoy the land are really the farmers who till the land,
yes,
and it will not go to a future buyer who might take advantage of a future sale.
In the sense that enjoy, you're cultivating it personally for yourself and for your family. Enjoy the land which has been awarded to you. And true, what you've said, to prevent our farmers, beneficiaries from being exploited by those who seek to take advantage of their economic situation. Sometimes our farmer beneficiaries have to send, and we've seen that, we have employees in the Supreme Court who are in such case they have to sell their land in order to give their children good education. And this really defeats the purpose of the Comprehensive Agrarian Reform Program.
And Justice, in the case that we're discussing today, Lim versus Cruz, there were specific transactions that gave rise to the dispute. Can you walk us through the whole dispute? What specific transactions gave rise to the dispute?
So, okay, we have Cruz here, who was awarded a farmer beneficiary. He was awarded parcels of land in Kalumpit, Bulacan, two parcels of land in Kalumpit, Bulacan in 1994, around July of 1994. And 6 years after, the first parcel of land was transferred to our petitioner, Lim, through a deed, well, not really transferred, was subjected rather to a real estate mortgage to secure a loan. So we know, of course, that purposes of real estate mortgage is to secure a loan. And there was for the second parcel of land, a month after, there was a sale. Okay, supposedly for the amount of 1.5 million for the loan, and also amount of 1.5 million for the sale of the second property. Okay, so years after, on 2011, Cruz, through his son, files a petition stating that there's a prohibition, okay, as we mentioned earlier, which prevents the sale, transfer, and conveyance of such property. Therefore, the sale that Cruz made to Lim should be nullified rather, for a more proper term. So with the real estate mortgage, it should be nullified. So they filed a consequent case with the Regional Trial Court of Malolos in Bulacan for the nullification of the real estate mortgage as well as the deed of absolute sale.
And there was an issue here as to where you should file the complaint in cases like this, because there was an issue of whether should it have been filed in the Regional Trial Court or the Department of Agrarian Reform Adjudication Board, or DAR. And what did the Supreme Court say about this?
Yeah, that was one of the defenses raised, Lim in this case. First and foremost, that's something I always tell my students. In a given problem, look at jurisdiction. Because really, if the court does not have jurisdiction, it's tantamount to a valid proceedings. A void judgment, waste of everybody's time.
Right.
So Lim raises as a defense, stating that the Regional Trial Court has no jurisdiction. It is with the jurisdiction belongs to the Department of Agrarian Reform Adjudication Board. It involves property, in a sense, involves property which was awarded through the Comprehensive Agrarian Reform Program. Hence, the RTC does not have jurisdiction. And how was this resolved? Okay, are we saying that if it's agricultural land, especially if it's land which was subjected to the CARP program, it should be with the jurisdiction of the DARAB? That is not always the case. So the Supreme Court tells us if the dispute, okay, not just because it involves agricultural land, and agricultural land which was awarded through the CARP, is jurisdiction automatically vested with the Department of Agrarian Reform Adjudication Board. Okay, the Regional Trial Court, for that matter, also has jurisdiction over disputes involving agricultural property which was awarded through to the Comprehensive Agrarian Reform Program. Okay, so how do we delineate? If there's an agrarian dispute, then jurisdiction belongs to the Department of Agrarian Reform Adjudication Board. If there's no agrarian dispute, then it is with the Regional Trial Court.
How do we define that, agrarian dispute? Is this the same as agricultural tenancy?
Yes, in the sense that, well, you can say that there's agricultural tenancy, agrarian dispute, if, well, the courts are really tasked. I've had this experience when I was in the first level courts. It sometimes involved a case for ejectment. And the defense raised that similar to this, it's an agrarian dispute. So courts are really tasked to look at the elements of agrarian dispute. What are the elements? First involves the landowner and tenant. Next, does it involve agricultural land? And of course, as I mentioned earlier, not all instances are agricultural lands. It's not just because it's an agricultural land, automatically it's the DARAB. Okay? So, not only should it be agricultural land, what is the purpose of the relationship of the parties? Is it for agricultural production? Was there consent between the parties for such agricultural production? And mind you, if I can elaborate a bit more,
Please go ahead.
is this consent could have been obtained impliedly, expressly, oral, or in written form. Good if you have a written contract. Good if maybe you can prove such relationship through testimonial evidence. But when we say impliedly, okay, it goes into what? The sharing of harvests. So jurisprudence tells us that if they're sharing of harvests, either in kind or in cash, consent is had. So, okay, so that's the other element. There must be sharing of harvest. So, without these elements, it is not an agrarian dispute.
So in this case, the court said it's just the second element that's here. It's an agricultural land, but all the others are not. So therefore, this is not within the jurisdiction of TARAP.
Yes,
but
it
the
belongs
RTC.
here to the RTC. We know jurisdiction of the RTC. This is a real action in this case. It involves interest, ownership, and possession of real property. Of course, some would say that, since we're calling for the nullification of the real estate mortgage as well as the deed of absolute sale, you may say that it's an action which is incapable of pecuniary estimation.
Yes.
But nonetheless, either way, it's the RTC.
RTC. So no question about that. It's the RTC. But what about the sale, the deed of sale that was executed? What was the Supreme Court's ruling on this? What was it valid? Was there a valid sale?
Okay, let's go back to Section 27 of our Comprehensive Agrarian Reform Act. It prohibits, as mentioned earlier, it prohibits the sale, conveyance, and transfer of the property. Therefore, since it is a sale, it should be declared void. It's prohibited. The sale was by cruise to limb was prohibited. That's why I'd like to go now to one of the issues really raised by limb. Yes, it may be prohibited, but cruise, you cannot go to the court because you have unclean hands. Raises the doctrine of pari delicto. And this was also something that was tackled by the Supreme Court in this case.
Interesting, because in the RTC said, essentially, you're the one who want to benefit from the problem you created.
And that was the reason why the RTC dismissed the case.
Right. So how did the Supreme Court discuss this?
You may have basis under the law, but, pari delicto, you have unclean hands.
Yes.
We note, diba? Cruz sold the property, and hence your hands are tied. You cannot invoke the law. Okay, in that case, the Supreme Court clarified here that yes, the doctrine of pari delicto exists. And what is the doctrine of pari delicto? It tells us that it finds basis under Article 1141, 1142 of the Civil Code. 1141 tells us that if there's an invalid cause for a given contract, and it in relation to the pari delicto doctrine, if there's an invalid cause and will bring about a criminal offense, okay, your provision 1141, Article 1141 of the Civil Code tells us that you, notwithstanding, you can still be prosecuted, but the parties to the case cannot prosecute each other. But in this case, it was not a criminal offense, but still there was an illegal cause. So we look at 1142. And in 1142 tells us that what? In relation to the pari delicto doctrine, tells us that, it may not have resulted into a criminal act, but again, parties are not allowed to have cause against each other. The Supreme Court in this case, used Article 1416, stating that yes, it may have been prohibited. I'm not saying illegal. The wording of the Supreme Court was it was prohibited, but jurisprudence, gives of exceptions, from the pari delicto doctrine, and precisely the exception is what? For the application of the Comprehensive Agrarian Reform Program. The exception given here is for agricultural tenancy and finds its roots in Article 1416 of the Civil Code, which tells us that if public policy is involved, in this case, Agrarian Reform Program, there is an exception to the Pire Delicto doctrine. Hence, notwithstanding cruise being really the cause of selling the property against the prohibition given in Article 26 of the Comprehensive Agrarian Reform Program, he may still file the case.
And the purpose, presumably, Justice, is really to keep the land within the tenant, or
Yes.
within the one who was awarded the land.
Yes. But, if I may, but
Go ahead.
so the disposition of the Supreme Court here is that the deed of sale being against prohibition of Agrarian Reform Act should be declared null.
So, Justice, what about Lim, who bought the land and parted with the money that went to Cruz? What happens to Lim?
If you look at the disposition of the Supreme Court in this case, it was remanded to first level courts, really, for the court to determine the actual purchase price. Okay, of course, there was a claim earlier that it was 1.5 million, but it has to be determined. But ultimately, what the Supreme Court is saying is that you cannot benefit, Cruz cannot benefit. The amount, whatever it is subject to determination, should be returned by.
And curiously, Justice, the Supreme Court did not actually touch on this anymore because it just affirmed the ruling of the Court of Appeals, which allowed the mortgage. So it disallowed the sale, but mortgage is okay for land that were distributed under the Carl program.
Yes. Well, I guess go back to what the Supreme Court did here is go back to the plain language of the Comprehensive Agrarian Reform Act. It prevents sale, transfer, and conveyance. We'll realize that a real estate mortgage, and as argued by Lim in this case, it was for a security for a loan. So effectively, if we're talking about property being subject to real estate mortgage, there's no transfer, there's no conveyance, there's no sale of the property. We're just holding this property out as a security for the loan. And in this case, I think it was claimed 1.5 million. So I think that's the reason why there was no nullification of the real estate mortgage, and any sale, transfer, or conveyance of such property, which was in this case subject property, is still subject to an extrajudicial or judicial foreclosure sale. That's when there's transfer, sale, and conveyance of the property.
So what happens when there's a judicial foreclosure sale, Justice? Will that not now be a violation of the prohibition for sale in that case?
Yes. Well, if we're talking about judicial foreclosure sale, what you're saying is that you're going to file a petition before the court.
I see.
So I don't think such cause of action will hold water. And let's just say it was subjected to an extrajudicial foreclosure sale, it would seem there's basis for nullification of such extrajudicial foreclosure sale, because that's when ownership transfers.
Yes.
So in this case, there was no transfer.
Yes.
Hold my property
Until
and
I'm
I
able to
promise,
pay.
until you pay for it. And if I pay for it, we can dissolve the accessory contract.
So from a policy perspective, Justice, how does this ruling balance the rights of lenders and the protection of former beneficiaries?
Okay, I think it's a reality. Sometimes, especially, like in our case, in what I know of is, let's say, the Palay now, they're buying it at such a low price.
Yes.
We just had our recent typhoon.
Yes.
So, ang daming nagbagsak na crops and what have you. And sometimes there is really a necessity for our farmer beneficiaries to, get extra income to make ends meet. So definitely cannot sell the property. But nonetheless, in the sense, people are saying that, okay, you may obtain a loan, you may use such property as collateral, as security for your loan, but a warning really for the lenders. In the sense that I don't think you can foreclose on the property judicially or extrajudicially within the 10-year prohibitive period.
And how often, in your experience, as a former judge of a court specializing on this, how often are cases like this when you have beneficiaries of land granted through the CAR program? They would sell the land and then there's a judicial process to nullify that.
As a judge, I don't really have experience, no. Kasi ibang cases ko dyan. But as, somebody from provinces, it happens often. I mean, they sell property, really, the term sell the property. But in this case, it really should be mortgage, really to make ends meet, to help their children get good college education. Sometimes what they do is they sell rights. I don't know how effective and it's based on they sell their rights to tenancy to other individuals. So it's really making ends meet for these individuals.
Yeah, really unfortunate, Justice. But for land awardees, lenders, and buyers, what lessons should they keep in mind when making decisions about transacting over agriculture or agrarian reform lands? What should they do?
Well, it's maybe easy for us to say that, make the most out of the land given to you.
Yes.
It's an award by government, and really, if you think of it, it's an asset that you really shouldn't dispose of, in the sense that, it's something that it's an appreciating asset, but yes, it's there, but sometimes they need the income.
Yeah.
So, I don't know if I can give them advice. I don't know what their situation is.
But what about the lenders and those who are buyers, for example?
Buyers, definitely. You're warned. Okay. Caveat emptor. You cannot buy property within the 10-year period. Within the 10-year period, you cannot buy property. And for those who are willing to lend, yes, you may lend. Of course, you want security for the money that you're parting with. Just be warned, that no sale can be effected within the 10-year period.
At least they've been warned. I'm not sure how many of people outside are actually aware of this rule. Justice.
I mean, seeing it on the ground. When I was a judge in Laguna, it's different. They have their own transactions for them. Okay, land has been awarded to us. I need to send my son to college. I'll sell my agricultural rights, quote unquote. I don't know what that is. Really, if you think of it, people, some individuals who used to till the land, and supposedly by their kids, by their children, it's someone else, which is nicer. I mean, economically, they've sent their children to college. They're doing better, hopefully, to provide a better life for their family.
But at least we learn something new every day. Thank you so much, Justice Jola, for joining us today.
Thank you very much, Attorney Mike, for having me.
All right. And if you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library and search for Elizabeth Ong Lim versus Lazaro N. Cruz, GR number 248650. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court en banc on Tuesday, November 11, denied the consolidated petitions questioning the constitutionality of RA number 12232, the law setting a 4-year term for Barangay and Sangguniang Kabataan or BSK officials. In upholding the law, the SC through Associate Justice Josep Lopez ruled that Article 10, Section 8 of the Constitution grants Congress the authority to set the term duration of barangay officials, who are not bound by the general 3-year term limit that applies to other elective local officials. Congress is the sole body empowered to define the term of office of barangay officials. The SC clarified that RA 12232 is fundamentally a term-setting law for BSK officials, establishing a 4-year term and prohibiting consecutive terms for the Sangguniang Kabataan officials. It is not a law postponing elections, as the rescheduling of the elections is merely incidental. The SC also ruled that the law does not violate the public's right to vote, as it neither abolishes nor indefinitely suspends the BSK elections. It is also not discriminatory, because the Constitution allows treating barangay officials differently. The court voted 8-5-2 with SC Senior Associate Justice Marvic Leonen and Associate Justices Alfredo Benjamin Caguiwa, Henry John Paul Inting, Antonio Co. Jr., and Maria Filomena Singh dissenting, while Associate Justices Ramon Paul Hernando and Amy Lazar Javier took no part in the deliberations. The Supreme Court has ruled that a congressional inquiry on the spread of fake news online did not violate the right to free speech of bloggers invited as resource persons. In a decision written by Associate Justice Amy C. Lazar Javier, the SC en banc dismissed the petition filed by Ernesto S. Abinos Jr. and other vloggers to prohibit the House of Representatives from requiring them to attend legislative inquiries involving their social media posts. According to the SC, simply inviting the vloggers as resource persons did not violate their freedom of expression, since the invitation did not regulate what they said or how they expressed themselves. Congress also cannot be prevented from inviting resource persons to legislative inquiries just because the topic involves speech, since it has the power to enact laws penalizing forms of speech that are not protected under the Constitution, such as those that create disorder or threaten society. The SC ruled that Representative Robert Ace Barber's privileged speeches did not violate petitioners' freedom of expression, as the same were not meant to silence or punish anyone, but to address, in his personal capacity, the deliberate spread of misinformation that harms not only public officials, but also ordinary citizens. The SC emphasized that Congress has broad authority to regulate matters for the common good. However, this power to conduct inquiries must be in aid of legislation, held in accordance with Congress's duly published rules of procedure and respectful of the rights of resource persons and witnesses. The Supreme Court has issued a stern warning to the public regarding recent fake and misleading statements falsely attributed to Chief Justice Alexander Hismundo. The misinformation presents a fabricated quote claiming that a supposed warrant of arrest issued by the International Criminal Court against Senator Bato de la Rosa could not be implemented without first going through the SC. The court stressed that Chief Justice Hismundo did not make this statement and that the quote is entirely false. For accurate and verified information on statements from the court, the public is urged to check the SC's official website or its official social media accounts on Facebook, X or Twitter, and Instagram. The Supreme Court en banc has approved the 2025 Code of Judicial Conduct and Accountability, or CJCA, which will govern the conduct of judges and justices. Among its salient features are strengthened rules on conflict of interest, financial disclosure, and standards of propriety both in and out of court, expanded accountability measures that link ethical conduct to performance, compliance, and discipline, guidelines on the responsible use of technology and social media, and promotion of gender fairness, inclusivity, and sensitivity in judicial behavior and communications. The SC Subcommittee, chaired by Associate Justice Maria Filomena Singh, conducted extensive consultations with stakeholders during the 2024 Ethics Consultative Caravan in Lipa, Davao, Bacolod, General Santos City, and Manila, ensuring that its provisions reflect the lived experience of those who administer justice through our courts. The SC will hold a special en banc session for the nationwide oath-taking ceremony where all justices and judges, as well as court officials and personnel, will take their oath of ethical conduct under the CJCA and the recently promulgated Code of Conduct and Accountability for court officials and personnel. The CJCA will take effect 15 calendar days after its publication in the Official Gazette or in 2 newspapers of general circulation and after its posting on the SC website. You are now up to date with the Philippine Supreme Court. I am Tifa Tendido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navalio as overall in charge of production, Attorney Karen Martinez as supervising producer, Jay Rempilio, executive producer, Tiff Atendido Beltran, producer, May Sibal, Attorney Ian Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vini Laranio as audio editors, Lawrence Olaño and Austin Aliscat as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalaki as web editors.